First and foremost, a very, very warm welcome from all of us here at ARAG and indeed from Stephensons for joining us this morning for the first of our Talk to the Expert series. Today we'll be focusing on the exposures of the haulage sector post-COVID-19. So here's a quick look at what we're going to cover off today. Obviously, there will be an introduction from myself and just a very quick overview of who ARAG are and why we are a specialist in the haulage industry. I will then hand over to Paul and the rest of the team, who will then go through obviously the impacts of coronavirus and how that has affected the haulage industry as well. We'll then look at the criminal investigations and proceedings with Sean. And then finally, we will also look at the implications for employers in general, which I think at the moment is very, very valid because, of course, we are all potentially exposed to these situations at the moment. So it'd be really interested to hear what we're going to go through, especially with employment law rights and how that's gone. As we said, we will then answer any questions that you may have. So if there's any questions that you'd like to ask at the end, please do. Okay, so for those of you that do know us, you would have probably heard this before, but for those of you that are new to the business, just wanted to give you an idea of who we are. We are an international business, and we were initially formed in Germany. And our German forefathers have a very, very strong belief in access to justice. So for us, that means just making sure that our clients have the best possible ability to challenge their legal rights. So as a business across the world, we are now in 19 countries. As you can see there, we are over 1.8 billion in income, which is fantastic for a family-owned insurer. Across the world, we predominantly write legal expenses business. There are a few different lines, especially in Germany, because of course that's where the mothership is. But the UK business was formed some 15 years ago, and from a complete standing start, you'll see there that we are now a significant business with over 1.9 million clients across the UK, and that is across commercial, personal and assistance business as well. So for want of a better phrase, we truly can be that one-stop shop. But what is really important to us, and the big success of ARAG has very much been that we are a specialist in specialists. We're very, very proud of our product development team, our underwriting team, of course, our claims and marketing teams as well, in the fact that we are all able to work together in order to make sure that we've got products that are fit for purpose and, of course, tick all of the boxes for our clients. And I think at the moment, especially in this time, now more than ever, I think people do need a USP that actually speaks that client's language. So we have a number of different sectors that we aim to make sure that we have specific wordings in. Of course, one of those is the haulage industry. So as you may know, our haulage product actually sort of focuses on our commercial offering that we have here at ARAG. But what makes it very, very sort of pertinent to these haulage clients is the fact that it speaks their language. When they're looking through their wording, they will see these covers that will come up and will be a serious problem to them day to day. You only have to think about traffic commissioners and tachograph offences, and I think people will start to shudder because these are very real life problems that they will come up with, which we will of course be discussing today. So this is based on our full commercial offering, and as you can see here, legal defence, statutory licence appeals and compliance and regulation do then have that sort of other level of specialist haulage knowledge that we're able to trade on. And as you can see there at the bottom, as part of our business, and we're very proud of this, we don't own a law firm. What that allows us to do is to partner with people like Stephensons and really give that client the true feel of working with a specialist in order to make sure that they're represented to the best possible standard. So from our point of view, we've partnered with Stephensons for an awful long time. They are one of our specialists in the transport sector, which actually will lead me quite nicely into the next slide, and I'll be handing over to Paul. So thank you, Paul.
Thank you, Chris. Good morning, everyone. So I'm going to be concentrating on the the regulatory impact really of COVID-19. As you all know, the regulator for this is the Traffic Commissioner. So it's more about how the Traffic Commissioner has responded to COVID-19 and what that really means for operators, for your clients really. Given the far-reaching impact of COVID-19 on many industries, it's clear that a lot of the industries are being restricted massively. This does obviously have an impact on the ability to comply with the regulatory requirements for hauliers. What the Traffic Commissioners, in my view, have very helpfully done and very proactively done is looked at relaxing some of those requirements in the interim. The basic requirements for licensing haven't changed, but in effect, a proportionate, or the principle of proportionality really is being applied by Traffic Commissioners to allow temporary relaxation of operator licensing conditions. Bearing in mind changing priorities, allowing for a flexible approach to be adopted in the administration of the regulation of the functions of the Traffic Commissioner, which is always underpinned by the main aim, which is to ensure safety. Okay, so the relaxations, if you like, were initially implemented to offer support for essential services. We all have an idea of what they are. So in this particular sector, it will be for those involved in the delivery of food, for essential non-food such as personal care, household paper and cleaning, door-to-door refuse collection, health service and over-the-counter pharmaceuticals, fuel or essential utility services. So for those really it was important that relaxations were put into place to allow those to function in actually a heightened pressurized situation for them. It does have some overlap and some implications and benefits really for those in general in the haulage industry, those who are not necessarily as part of those essential services. And the Senior Traffic Commissioner recognised at the outset that there may be challenges for operators in meeting these requirements for the operator licensing conditions, and key considerations within this were undoubtedly considered where there was potential for personnel changes, for issues with economic activity having an impact on the business. And for those reasons really, the basic principles have been slightly adapted, albeit in the short term. The Traffic Commission's mission statement is there, which really just suggests that there needs to be a balance really between road safety, fair competition, efficient passenger and goods, in this particular instance, transport. Okay, so again, whilst the basic conditions of the licensing conditions haven't been changed in the sense that any have been taken out of the equation, some of them have been adapted. So initially, in relation to the impact it has on transport managers, that there is a clear implication there for transport managers, and the impact that has on an operator. Having a transport manager for a professional haulier, for a standard licensed operator, is integral. It's a prerequisite, it's a condition. That is really to be able to demonstrate that there is the proper or requisite level of professional competence within that operation. So this recent crisis has obviously brought to light some areas of concern relating to temporary illness, relating to the issues surrounding furloughing, where there has been a normal situation of an operation which is effectively closed down. The argument is more simple. The Traffic Commissioner doesn't necessarily need to be engaged to grant what we call a period of grace to allow for the temporary stand down of a transport manager. Where the operation isn't operating, then the transport manager isn't expected to be in operation within that. There are issues with operations which have temporarily reduce their operations. So they're looking at potentially furloughing a transport manager but continuing an operation. And in those situations, it has been necessary for an application for a period of grace to be made to the Traffic Commissioner. Driver's hours regulations can seem daunting, can seem quite easy to contravene for a number of people if you don't keep a close eye on them. It's integral that for a number of reasons, both regulatory and even for criminal implications, that these hours are adhered to, and they aren't bendable. In this instance, the Traffic Commissioner did issue some temporary guidance or some temporary relaxation to these rules on the 18th of March. They were actually withdrawn on the 14th of June after being extended from an April date, such is the impact that the pandemic has had. These measures, these relaxations, were really intended to provide relief to those operators who were providing emergency or necessary journeys, and it is necessary to be able to demonstrate to the Traffic Commissioner that any use of the relaxed regulations directly relinks to that sort of activity. So they need to be able to show that they were either providing goods or services to protect public health and or meeting theirs or others' basic needs for day-to-day living and or providing medical treatment. So effectively, they need to be able to show that there's a risk to the life or health of people if the journey can't be carried out. Now, without going into too much detail about the relaxation measures, some examples are that when looking at EU driver's hours rules, the replacement of EU daily driving limit of 9 hours has been increased to 11 hours, and then the reduction of a daily rest requirement of 11 hours has been moved backwards to 9 hours. So they're effectively looking to be more flexible and less stringent on drivers and intern operators to ensure that the emergency delivery of these services. One of the key issues when issuing the temporary guidance was the impact this might have economically on operators. It's clear here that this is something which is running through this industry certainly, but business in general. Financial standing is a requirement of an operator licensing system whereby you need to be able to demonstrate that you have necessary access to available and immediate financial resources to support the maintenance of vehicles and trailers during the operation. Okay, so in that instance, if that can't happen, then any changes must be notified to the Traffic Commissioner. In those situations, what would need to happen is an application for a period of grace. I've mentioned that term a couple of times now. The period of grace is really for the Traffic Commissioner to take stock of your situation and decide whether to give any leeway where you can't comply with the basic requirements. So what's happened with financial standing is not that the requisite levels of finances that you're supposed to be able to demonstrate has been reduced, but what has happened is your ability to demonstrate that in some instances the Traffic Commissioners are given a period of grace, so given really an allowance for when there may be an economic downturn. Operators have to be able to meet certain requirements before that is accepted by the Traffic Commissioner. The key to all of this, you'll probably see, is that there has to be that level of communication with the Traffic Commissioner. There are certain instances where automatically you can take the lead when looking at the issued guidance, but the guidance is voluminous and it's frequent. So it's always best for your clients to be contacting the Traffic Commissioner's office directly to get assurances that way. It does remain crucial to comply with training requirements during this period. So, like every regulated industry, there are continuing professional development requirements. There are often undertakings whereby an operator might need to comply with certain training by a certain date, and that undertaking may actually be stipulated on the licence or linked to the licence. There may also be an undertaking for outside auditing of the maintenance systems to be dealt with by a certain date. Now again, where that hasn't been possible due to the restrictions, what has to happen really is there needs to be that level of dialogue, that level of communication, as was suggested with the Traffic Commissioner, to explain why that's not possible and ask for an extension where necessary. Moving forward, which we'll see shortly, the training has now been implemented and approved by the Traffic Commissioners so that it can be dealt with remotely and it can be dealt with online, which is something which has really moved this sector forward. Similarly, remote auditing, that's something that is now coming into play, and although there are certainly strict requirements for evidence to be produced to independent transport consultants for any audits and processes, there is a situation where that can be done remotely. Some other examples without going into detail are the ability for an exemption where there's a temporary unavailability of an operating centre for any reasons related to the pandemic, a temporary increase in vehicle authorisation, and temporary ability to operate for hire or reward. So where a restricted licence holder is looking to effectively operate as a standard licence holder, there are those measures in place where the Traffic Commissioner can grant those in the interim. What is going to be the new normal? Well, again, like most industries, we're still uncertain what post-COVID-19 will look like and actually when that will actually be. What we've seen in this particular sector is there has been an embracing of online technology with, for example, remote hearings having taken place. I personally took part in a remote case management hearing which was situated in Eastbourne, dealt with by way of Teams, similar to this. Went without issue, and I think we will see more and more hearings dealt with in that way. Traffic Commissioners, though, will still have a preference for face-to-face meetings and face-to-face hearings, and they have actually very recently been reinstated as of the 6th of July. We ourselves have some in the diary, but looking really in the coming months, how they will play out. I imagine not too dissimilar to how they were before, really, because for those of you who may know, Traffic Commissioners' hearing rooms are relatively spacious in any event. They're allocated to one specific hearing, so social distancing measures will be quite easily dealt with within those settings. For operators in general, I think the key message from all of this is that the changes have, I mentioned before, been voluminous, and they've also been frequent. It's more important than ever to stay vigilant and keep abreast of these changes, and to really have that level of communication with the Traffic Commissioner if they're concerned about not complying with any of the standard licensing conditions. Failing to do that, and failing to comply even with the temporary driver's hours relaxations that were implemented that are no longer in place, and anybody who hasn't complied with that during that period and has potentially breached issues, it's not necessarily over. We will see investigations in the future by DVSA. We will see it by the police. They are ongoing at the moment. So as well as regulatory action, people are leaving themselves open to action within criminal courts, which again have faced their own difficulties. But I think that brings us nicely really to Sean to move on to that next part.
Thanks, Paul. Yes, I'm going to talk about the impact that coronavirus has had on the criminal justice system as distinct from the regulatory system that Paul's been talking about. The difference between the regulatory regime and the criminal justice system is that in the regulatory regime, traffic commissioners deal with the kind of rule breaking that Paul's been talking about, and they can, as well as grant licences, revoke licences, suspend them, curtail them, which means reduce and limit the number of vehicles that can be operated on a licence. They can also suspend and revoke vocational driving licences of HGV drivers, or they can impose conditions on operators' licences. What traffic commissioners can't do within that regulatory regime is impose punishments. So if you have insured clients who are called to a public inquiry before the traffic commissioner, one of the things they don't need to worry about is the risk of having to pay fines or costs, because traffic commissioners have no power to impose those kind of financial penalties, and they certainly don't have the power to impose things like prison sentences. More serious misdemeanours that amount to criminal offences rather than mere rule breaking, however, can see operators and drivers arrested, charged and prosecuted for offences and punished by criminal courts. And in the most serious cases, operators, managers and drivers can be sent to prison. So that's the main difference between the regulatory regime and the criminal justice system. Before COVID-19, the criminal justice system had already been in crisis for quite some time. This is as a result of years of chronic underfunding by a succession of governments that was placing all parts of the system under stress. So that includes the police, the CPS, the Crown Prosecution Service, the courts, the probation service, the prison service, and also the legal aid system and defence lawyers. They've all been underfunded and overworked, and the system really was at breaking point. And the government were already conducting a root and branches review with the biggest consultation of the entire system that they've ever had in living memory. And then along came coronavirus, which of course has made things even worse by creating even more delays in the system than there already were. The courts haven't stopped moving, they've just slowed down. And to give you some statistics to put that into context, currently there are said to be 40,000 Crown Court cases waiting to be dealt with in the system, and 500,000 Magistrates Court cases, which is an eye-watering backlog. Prior to COVID, there were already a lot of cases in the system that had been under investigation for a long time, but the investigations hadn't been concluded. We've seen a lot of those historic investigations that had been on hold, where they'd been awaiting advice from lawyers, from CPS and such, have been concluded during lockdown. So defendants have been charged with offences, and in quite serious offences in many cases. But then once the cases get to court, because of the backlogs, those cases have then been adjourned. So in the Crown Court, any cases that are estimated to have a trial that's going to last for more than 3 days are generally being adjourned until next year. And in the Magistrates Court, we've seen cases just automatically adjourned administratively without defendants or lawyers having to attend court for 2 to 3 months. And we're now seeing the first batch of adjourned cases come around, and they're being adjourned again. And the dealing with that backlog is quite a task that's taking some time. Delays can work to the advantage of defendants, because victims and witnesses can sometimes lose interest if cases drag on. And also there is a strict 6-month time limit for what we call summary only offences, which are the less serious offences that are dealt with in magistrates' courts, offences where the maximum sentence is 6 months in prison. For lots of those, for most of those in fact, there's a 6-month time limit for bringing a prosecution. So if investigations aren't concluded within that period, within that 6-month time limit, then there is a bar to prosecution and defendants avoid justice. And that applies to a lot of simple driver's hours breaches. So delay can be fatal to many prosecutions. The typical cases that we deal with routinely involve driver's hours offences, tachograph falsifications. We have been lucky enough to have been involved in some of the biggest jury trials for tachograph offences in the country, a number of those. involving large-scale conspiracies to falsify records, where it's been alleged that owners, operators, the management and also the workforce have all conspired together to systematically falsify records in order to conceal widespread driver's hours offences. And these are investigations that take many, many months, in some cases years, to compile all the evidence, and then the cases can take months to get through the court system at the best of times. And the trials can last for weeks in some cases. In cases like that, expert evidence is crucial. We've built up a network of some of the finest experts in the country. Quick example, the case we dealt with involving conspiracy to falsify records. It was alleged that drivers were making journeys with the tachographs turned off. And there was all kinds of expert evidence from the prosecution to substantiate those allegations. And we managed to secure the assistance of the country's leading electronics expert, who's an expert in GPS evidence. And we were able to prove with his help that actually these vehicles were being parked on car parks on occasions, on service stations next to motorways when drivers were taking their rest at the end of the day. They were switching the engine on, so the vehicle's electronics came on so that it could use the television and the kettle, for example, of an evening. But what that was doing was also turning on the GPS tracking system. And the way that GPS works is it plots the position of a vehicle using longitudinal and latitudinal data, and then plots it onto a map such as Google Maps. And in this example, it was sometimes placing the vehicle, moving the vehicle off the car park onto the carriageway of the motorway, so that the system, the GPS system, thought the vehicle was then on the motorway, and the only way it could get back to where it was to move up the motorway to the next exit, go around the exit, come back and get back on the car park, where in actual fact the vehicle wasn't moving at all. So we were able to disprove a lot of the allegations. That's just a quick example as to what difference expert evidence can make, and without that expert evidence we'd have never been able to prove it. So in terms of the response of the criminal justice system to coronavirus, starting with police stations and interviews under caution, as far as road transport offences and hauliers are concerned, they could be interviewed either by the police or the DVSA. And in either case, all suspects are generally interviewed under PACE, which is the Police and Criminal Evidence Act, and the interview takes place under caution. And suspects have the right to legal advice, which can be over the phone or in person from a lawyer. Usually, when an interview takes place, solicitors provide that advice face-to-face, and they'll have a face-to-face consultation with the client in the police station or the DVSA office prior to the interview, where they'll advise them as to the evidence and how to deal with the interview, and then they'll sit next to them during the interview and advise them throughout the interview as they're being asked questions. It's a lot more reassuring to have that lawyer physically sat next to you. However, as a result of social distancing in recent months, which is very difficult to achieve in police stations, we've seen the implementation of protocols in many police areas that discourages the attendance of lawyers, save for in the most serious of cases. And a lot of interviews have been taking place, and advice delivered by solicitors has taken place using video conferencing facilities like Skype, Microsoft Teams, Zoom, or even the good old-fashioned telephone. One of the problems with that is that data receptions and Wi-Fi connectivity and mobile phone connections in police stations are always notoriously poor, which can make communication very difficult. In some police stations, they insist that the client consultations take place either side of the screen, and some police stations just have no facilities at all, and they just expect solicitors to have a quick chat with their clients over the phone and then for the suspects to go into interview alone, which is not satisfactory. And there's definitely evidence of the police actively discouraging solicitors from attending in person. Police cells generally don't have carpets or furniture, so the acoustics are very poor, they're very echoey. So trying to speak to a client who's in a cell is less than ideal. You can't really have a private conversation, and there's also the risk that the police officers or DVSA officers could be sat outside the cell door listening in on private consultations. And the Police and Criminal Evidence Act hasn't changed. Suspects still have the right to face-to-face legal advice if that's what they want when they're being interviewed under caution, but it's not often clear to suspects. And one of the key messages we'd like to try and get across to people is you still have that right and you can insist on it. Interviews under caution generally take place in one of two ways. The first is by pre-arranged appointment when suspects are invited to attend as a volunteer. They're quite easy for us to deal with as lawyers because clients can contact us in advance, we can have a chat with them in advance about the case, and we can arrange a time and date that's mutually convenient to all parties, and we can then arrange our diaries around that. The alternative is that suspects in more serious cases can be arrested without notice and taken to police stations in handcuffs without any warning, placed in a cell, and then interviews take place at very short notice. And they're more difficult to respond to. And contrary to popular belief and all the sort of police station dramas that you may have seen, there is nothing in PACE that says you have the right to a phone call. You don't. What you have the right to is to have somebody informed of your arrest, but often that involves the police informing them on your behalf, and you have the right to a consultation with a lawyer, as I said, either over the phone or in person. And normally, initial contact is over the phone, a bit of initial advice is delivered over the phone before you then attend in person. But suspects are told by the police that they can either nominate a solicitor of their choice, which is known as own solicitor, or a solicitor can be provided to them by the duty solicitor scheme if they don't have a solicitor, they don't know of any solicitor details. Transport law, however, is very niche, and I would say that someone with specialist knowledge of transport law and driver's hours, etc., should ideally be involved at an early stage. And policy holders should be encouraged to ask either for their insurer or their broker to be notified, and then insurers and brokers can in turn notify panel solicitors who can then make contact with the investigating authorities, the custody suite. And custody sergeants should be told that their insurer will nominate a solicitor for them. The key point is that policyholders who know that they have cover for situations they find themselves in should be encouraged to ask the police for their broker or insurer to be contacted so that panel solicitors can be nominated from the outset. And you should really consider giving policyholders some form of emergency contact details in the event of arrest and interview at short notice. And if you can't provide that yourself, then consider providing contact details for panel solicitors direct to clients as part of the policy contact details. Following on from the investigation and the interview under caution, prosecutions always start life in the magistrates' court. Since March, as I said earlier, magistrates' courts have been adjourning cases automatically and administratively, and they've only really been prioritising the most serious of cases, which generally includes cases where defendants are in custody, where bail has been refused by the police and they're appearing from custody. Those cases are dealt with within 24 hours or within one working day and can't be adjourned easily, so defendants are produced in person or appear back via video link. But cases on bail have been adjourned, as I say, administratively for periods of between 2 and 3 months, with defendants and solicitors given new court dates in writing and told they don't have to attend. And bail's extended and new dates are fixed. And then, as I say, in many cases, when those court dates are now coming around because we're 2 to 3 months further on, but they're being adjourned again. Generally speaking, the court service is now starting to clear that backlog, but it is a slow process. They've introduced a variety of measures in the magistrates' courts to do that, including what they call the brigading of cases, which involves block bookings for law firms. So we, for example, have a lot of cases in the northwest, so the northwest courts have been listing all of our cases that we're dealing with in one courtroom in one session, so we can get through them quickly, because that's not what normally happens. They're also getting district judges who are professional lawyers to deal with as many cases as possible, as opposed to lay magistrates, because that's generally quicker. But there is a fear that this sort of rush to deal with cases quickly to clear the backlog could have an impact on the ability of courts to hear cases properly and for justice to be properly administered. The unfortunate thing is that not many people outside of the criminal justice system are likely to care about that. The more serious cases progress to the Crown Court, which is where you have the jury trials, and the Crown Courts have been generally worst hit and most affected by coronavirus, and we're seeing some very long delays, particularly in the most serious cases. That's mainly because they've had the added problem of having to accommodate juries with social distancing. And in the majority of Crown Courts, any cases with trials that are estimated to last more than 3 days have been adjourned for many months, and in most cases until next year. There has been a written response to the crisis from Her Majesty's Court and Tribunal Service that talks about the need for radical action, and there are now proposals for the Crown Court to clear the backlog by introducing extended court hours, which means early mornings, late evenings and weekend court sittings. But more controversially, there is also now talk of removing juries from some trials. That would be quite a significant step for the criminal justice system. Jury trials are sacrosanct in our system. It's not yet clear what the criteria might be in terms of selecting cases to be dealt with without juries, but it has caused uproar amongst the legal profession, and they have been objecting strongly to that proposal. The very thought of abolishing jury trials is a notion which most lawyers find offensive, because they think that it will seriously undermine the criminal justice system, which is still held out as being the best in the world. There may also be a more pragmatic approach adopted to the prosecution of cases by prosecution authorities such as the Crown Prosecution Service and the DVSA, and some fear that that will amount to a criminal charter, because in reality it could mean dropping more cases and only going after those cases where convictions are thought to be more easily achieved, where the evidence is stronger. I just wanted to say a few words about what's become known as furlough fraud. There's a lot of talk about this within the criminal justice system at the moment. It's a new emerging fraud linked to the government's furlough scheme. As you'll all know, the coronavirus job retention scheme has also become commonly known as the furlough scheme, was hurriedly implemented by HMRC to mitigate the effects of COVID-19, to help businesses affected by coronavirus to hopefully avoid making staff members redundant if at all possible. The scheme was introduced at short notice on the 20th of April, but by backdating it to include workers on the payroll from the 19th of March, they have made it almost impossible for anyone to make up fictitious workers and commit fraud in that way. That would have been too easy. However, as with any financial scheme, particularly one introduced as hurriedly as this one, there are ways for fraudsters to take advantage of it. HMRC are taking this very seriously. There is a Furlough Fraud hotline that's been set up. There are thought to be 3,000 whistleblowing reports received by that hotline that allege employers have been misusing the scheme, and HMRC can inspect businesses at any time. Last week we saw the very first arrest for furlough fraud, which was reported in the West Midlands area. The alleged fraud in that case involved what was thought to be £450,000 of furlough grant, and the defendant, or the suspect in that case, was also arrested for money laundering offences. More than 100 officers from HMRC's Fraud Investigation Service were deployed to 11 locations to investigate the issue, and the company's bank accounts were frozen and computers were seized during an office raid, along with other digital devices. So that gives you some insight into just how seriously HMRC are taking this. It is likely that we'll see prosecutions of furlough fraud in the coming months, and the courts are likely to come down very hard indeed on anyone who's convicted, because this is taxpayers' money that's been set aside to protect jobs, and fraudulent claims deprive a vital public service and essential funding. And the general public are likely to disapprove of such behaviour and will expect those that commit those offences to be punished severely. And I think for those reasons we can expect some heavy prison sentences for anyone convicted of abusing the furlough scheme. So as I said, although you can't really make up fictitious employees, there are some ways that furlough fraud can be committed, and I've listed on that slide there some of those methods of committing the fraud. So the first is if the company incentivises by, for example, paying cash in hand, or pressurises furloughed workers to carry on working even though they've been placed on the furlough scheme. They could be redeployed to a connected role, so it might be that because of course the scheme does allow you to go and work for another company, even though your main employer may have placed you on furlough, providing your employment contract permits that and your employer consents. So there is the risk that some employers will redeploy workers to go and work for a sister company within the same group, or just ask them to carry on working off the books, as it were. Working overtime whilst on a flexible furlough scheme, so this is where companies can bring workers back for part-time, for example, does contravene the HMRC guidelines, so that's another way that employers can get themselves into trouble, even inadvertently. Or even simply not telling workers that they've been placed on furlough, so claiming the furlough grant, but allowing the workers to carry on working in ignorance of the fact that they've been placed on the scheme. There's also a small group of workers who may have left their employment since the 19th of March for various reasons, but employers carry on claiming the furlough grant in respect of those workers. So they're just some examples as to how unscrupulous employers could take advantage of the furlough scheme. In terms of who offences and penalties, well, the offences that can be committed are basically straightforward fraud under the Fraud Act, cheating the public revenue, or conspiracy to defraud, because very often the involvement and knowledge of workers is required in order to commit this kind of fraud. And if you involve employees or managers in the fraud, then that's when it becomes a conspiracy where multiple defendants agree to take part in a joint activity. So potential defendants include the companies themselves, directors and officers of those companies, managers within the companies, but also the workers themselves who are placed on the furlough scheme. And the penalties for fraud are up to 10 years imprisonment. And as I said, I think we can expect some heavy prison sentences. In terms of what hauliers can expect from the criminal justice system, just to recap, it's still uncertain how this will imminently affect hauliers. But what people need to be aware of is that if we're in a period at the moment where lots of companies could be making workers redundant, and that could lead to lots of disgruntled employees who whistleblow and contact investigating authorities to make allegations about employers if they're unhappy with the way they've been dealt with. And also, we also could see lots of companies cutting corners and prioritising economic survival over compliance. And we think that there's likely to be an increase in regulatory activity and criminal prosecutions in the coming months as we come out of lockdown and this kind of behaviour starts to be uncovered by the regulatory authorities. So that's all from me. I'm going to hand over now to my colleague Adam Pennington, who's an employment lawyer, who's going to touch on the furlough scheme from an employment perspective.
Morning, everyone. My name's Adam Pennington. I'm a specialist in employment law. Where do I begin? So I think it's worthwhile starting just a brief overview of what the tribunal process looks like. So using an example of a dismissal, the dismissed employee will have 3 months, less a day from that dismissal date, to get in touch with ACAS. ACAS early conciliation is now a legal requirement, and that's a prerequisite before anyone else can move on to a tribunal. And so for your clients or policyholders, one thing that they may have an eye on is at what point are they allowed to appoint a solicitor. So the policy may allow for the solicitor's involvement at the conciliation stage, or it may only allow for involvement at the point at which a claim has been issued at tribunal. What I'll come on to explain, and what we've certainly seen a lot of, are individuals representing themselves, which for your clients and our clients can be, well, those individuals can prove extremely volatile. And it's important to bear in mind that in the tribunal proceedings, we're in a cost-neutral environment. In other words, that employee or that disgruntled employee can run their case into the ground, have their day at court, and if they lose, they lose. They're not responsible for paying the other side's costs, unless they were to act vexatiously or unreasonably. But an individual representing themselves, we find frustratingly that the tribunal is very lenient with them. So I'm assisting a number of companies at the moment against individuals who are representing themselves, and it's very difficult to appease to the rational or reasonable side of those individuals. So particularly for policyholders, it can be extremely difficult where they're representing themselves. I just wanted to start with an overview of some of the implications or ways in which employment rights have changed slightly by the furlough scheme. And I'd be lying if I said it's not been somewhat of a minefield, and that's me saying that. So for companies themselves, this has been extremely tricky. Guidance has been sent through day to day. HMRC guidance has altered, and the way in which some of the guidance is interpreted changes from one solicitor to another. So you can expect an influx of claims, or an influx of companies or organisations leaning or looking on the policy to try and defend some of these, whether it's from unlawful deduction of wages through to discrimination and unfair dismissal. So just briefly looking through these, and I think as you look through, an employer potentially would be wincing thinking at how this can go terribly wrong for them. So it's recommended that anyone who's been placed on furlough, that there's a written agreement in place, because essentially if you're asking someone to take a deduction in the pay, it's a contractual change, and there needs to be some agreement in writing. As Sean touched on earlier, employees can work elsewhere while on furlough, but not for organisations linked to the employer. So where we're seeing some issues arise is where an individual will go and work somewhere else, but at the point at which the original employer wants them to return, they're required to serve notice with the new employer, and that individual is sort of stuck between the two, and they're contractually obliged to parties. Employees can take annual leave while on furlough and carry untaken leave up to 4 weeks into the next year. Again, a discussion around whether or not that individual is entitled to 100% holiday pay. In other words, the employer would have to top up 20%. Again, there are differing views on that and the interpretation of the guidance issued by HMRC. Employees can be switched from sick pay to furlough and vice versa, but currently there's no right to statutory sick pay while on furlough leave. It's one or the other. Furloughed employees can be brought back part-time. They're entitled to statutory sick pay if they've been told to isolate under the test and trace system. And you can see in the following sections, that's the timeline by which the job retention scheme will be winding down. So from the 1st of August, employers will have to pay NI and pension contributions. 1st of September, the government will reimburse only 70% of salary, employers topping up to 80%. 1st of October, the reimbursement drops down to 60%, the employer having to top that up again further. And then the furlough scheme will come to an end on the 31st of October. So you can see, just considering some of those particular areas, the potential claims that could arise from this, and the difficult situations that employers can find themselves in. Some of these claims, there's nothing unusual here, but what we're seeing is the volume of the claims that are emerging. So companies may be relying on dismissal instead of considering furlough. In other words, is furlough a reasonable alternative or suitable alternative to dismissal? And in a lot of cases, the answer to that is potentially yes. So it might be tricky for a company to defend a decision to dismiss when there was the option of the furlough scheme. Where there's a number of redundancies taking place, particularly in excess of 20 individuals at risk, the company has an obligation to collectively consult with those employees. If they don't, and again, this is an issue for the policyholder and certainly the level of indemnity, we've seen the likes of Debenhams and other stores closing down into administration. But for those companies that don't enter administration, dismiss, and there isn't that, they fail to comply with the duty to inform and consult, the tribunal can award up to 13 weeks for each individual employee. I'm assisting at the moment with a case not too dissimilar. That involves the dismissal of around 60 or 70 employees, each of those claiming 13 weeks pay. The value of that claim is somewhere in the region of £600,000 or £700,000. Slightly complicated with a TUPE factor as well, but it just goes to show for the policyholder, depending on what the level of their indemnity is, and how the policy is worded as to whether or not it will provide cover for each individual claim, or whether or not, because it's brought as a group action against the company's going to have to top up some of the legal costs. Constructive unfair dismissal. So with what's happening at the moment with the furlough scheme and obligations on employers, we have at the centre of any contract of employment this idea of mutual trust and confidence, and it's if an individual is to resign and claim that there's been that fundamental breach, they will be looking to pursue claims for constructive unfair dismissal where they've been employed for at least 2 years. So a scenario where certain individuals have been furloughed but others haven't, some have been brought back from furlough, others haven't, and it's that idea of that disgruntled employee where they get the impression that the employer hasn't been open and honest with them in the way in which they've conducted themselves during the furlough period. And so in those circumstances, the company doesn't have to dismiss. They may act in a way that fundamentally breaches the trust and confidence, and that will entitle the employee to resign. The next 2 claims, though, however, we're seeing far more of these emerge. Whistleblowing and victimisation. Just very briefly, a whistleblowing claim is where someone raises what's called a protected disclosure, and that's a disclosure that's in the wider public interest. There's a couple of hurdles the employee needs to get through to make sure that it is a public interest disclosure. But having established that, if they are put to any detriment whatsoever as a result, they will have a claim for whistleblowing. The important thing to bear in mind for the policyholders and your clients, it doesn't matter as far as whistleblowing and victimisation is concerned how long the employee has worked. So a practical example in the haulage industry, or any industry for that matter, is an employee reluctant or refusing to return to work because they say the company, in their opinion, hasn't taken reasonable steps to protect their health and safety. A scenario then ensues where that individual is dismissed. If that individual can prove that they were dismissed for raising that protected disclosure, whether they've been employed for a day, a week or 2 years, their dismissal will automatically be unfair. Similarly, with a victimisation claim, that is where someone alleges that their employer or someone else has breached the provisions of the Equality Act. So the Equality Act is in place to cover all aspects of discrimination on the grounds of age, race, gender, religious beliefs. So again, a situation currently, we've got someone who's in isolation, who's shielding. The employer asks for them to return to work. They refuse, and there is a dismissal. Again, it doesn't matter how long the individual has worked there for. They do a protected act by telling the employer that they suffer from a disability, they're vulnerable and therefore unable to come into work. And it doesn't necessarily have to be dismissal, any detriment whatsoever. It may be a decision to keep that employee on furlough longer than anyone else. The term detriment is quite wide, and so it's not unusual where we're assisting employees, we'll have a whole list of detriments that the employee is relying on. Discrimination. So again, with choosing who to put on furlough, companies need to be careful that the decision isn't motivated in any way by discrimination. To an extent, it may be unavoidable. So there may be someone who does suffer from a disability, who is vulnerable, and as a reasonable adjustment or to avoid any further risk to them, they're placed on furlough. Employees at a particular age, they may potentially argue that they've been placed on furlough because they fall in a particular vulnerable category. The companies in these situations can objectively justify discrimination where the reason they're placed on furlough isn't because of that protected characteristic itself, but it's because of something arising as a consequence of it. So there is a way in which a defence can be brought. Breach of contract, particularly with the change to people's pay, the taking on and off of furlough. Each time that's happening, there is a change to the contractual terms and both parties need to be in agreement. A scenario which you may have come across, for example, is those refusing to come back from furlough, or the furlough agreement doesn't provide how long they will be on for. It's at least 3 weeks, and the employee is concerned they don't want to come back, and then the company is stuck in a difficult place of trying to bring them back in. So a huge risk for breach of contract on both sides. and of course that feeds in as well to unlawful deduction from wages. So very difficult for employers where their staff work irregular hours on particular shifts, and they're shifting between furlough leave and back in. The number of inquiries that we've received from employees is vast in that regard. And again, it can be a nightmare for companies where they're facing claims in early conciliation or at tribunal for individuals who have set out a detailed breakdown of their salary, how it fluctuates, and where they say that the employer has there's been an unlawful deduction of their wage. So what does this mean, or what's the risk? I've just briefly set out there the value of some of these claims. So unfair dismissal, maximum award, basic award, and that's calculated in the same way as a statutory redundancy payment. The compensatory award as part of an unfair dismissal claim is that employee's ongoing loss of employment from the date of the dismissal or the date on which they resign. So they will continue to hemorrhage a loss until they find work elsewhere, or they have the day in court and the judge decides how much to pay them. A week's pay is capped at £538 gross, and an additional award for any future loss. The main thing to bear in mind is those claims where there's no limit on the compensation. So those claims for whistleblowing, those claims involving victimisation, so we make a protected disclosure, discrimination, and so the employer needs to bear in mind, as I say, that there is no minimum 2-year rule in those circumstances. Companies can end up also in a situation where, for example, an employee may be employed for 2 months and they raise concerns about the company's failures from a health and safety perspective, and that employee resigns claiming constructive unfair dismissal. Now, with a constructive unfair dismissal claim, the fact that they have resigned is academic as far as the tribunal is concerned. If the tribunal is in agreement with that employee that there has been a failure as far as health and safety is concerned, and that employee is entitled to resign, believe it or not, despite the fact that that employee has been employed for less than 2 years, they can claim that their dismissal was automatically unfair. They will say they were dismissed because of those health and safety concerns. So a company may be scratching its head thinking, well, they've only worked here for 3 months, how can they claim constructive unfair dismissal when you usually need to be there for 2 years? So these claims can manifest themselves in a number of ways, and at a time where health and safety and people in a vulnerable position, when that's sort of brought to the forefront in light of what's going on, these are the claims that we're seeing emerge. These are the claims which companies and employees are getting in touch with us about. And lastly, the cap in the tribunal for a breach of contract claim is £25,000. So how can companies reduce the risk? The main thing, the overarching thing, and certainly what we advise our clients, is to consult with staff. Those who have been on furlough, those who are coming off furlough, any decisions around pay, where employees feel that companies have just take a broad brush approach, it's at that point I'm finding that there's more momentum in the concerns because they feel that they've not been involved. Obtaining written agreement where necessary, so furlough agreements. If there is a decision to bring someone back, put them back on furlough part-time, it's always going to assist the company if they have a written record of that. Minuting meetings where possible. Again, this can be time-consuming, but particularly later on where an employee is alleging to the judge that during a particular meeting they said something and it was because of what they said they feel that they were dismissed because of it. So to tie back into the whistleblowing and victimisation, the minutes of those meetings can be worth the weight in gold. Following up any substantive decisions in writing. So There's nothing worse for us when we're looking to try and defend a company, particularly against claims for whistleblowing, where there is some disparity between the reason for the dismissal and the position on the ground before they were dismissed. So, for example, an employee is dismissed over alleged performance concerns, yet their employment record shows that there were no concerns with performance whatsoever. What we do have in that timeline of events is an employee saying that they will not come into work because they're not happy with the precautions or steps taken by the company. So if an individual is dismissed for refusing a reasonable management instruction, so they say, well, I'm not coming in because I don't think it's safe enough in there. If the dismissal or the sanction, the disciplinary sanction, is because of their refusal, it's important to set that out in writing. Any ambiguity in that decision or a failure to commit to putting the decision in writing just leaves that employee with far more wiggle room, and they're allowed to speculate as to what the reason for that decision was. And that's where you start to see the whistleblowing and victimisation claims falling through. Redundancy policies and procedures. Again, whether or not the policy would cover a company for having someone review any policies that they have in place. The number of companies I've assisted in the past where I asked for a copy of their policies and procedures and the sort of scribbled down on the back of an envelope, having a structured policy in place which that company can follow to the T, particularly because in a lot of circumstances, as far as the tribunal is concerned, it isn't for the tribunal to substitute its view with the companies as to whether or not they would have made people redundant. The tribunal is only there to make sure that the company followed a fair and reasonable procedure. So having those in place and allowing the company to follow through with those is going to pay dividends in the long run if they were to face an unfair dismissal claim. A whistleblowing policy. The main benefit of having one of these policies in place is the fact that a company can avoid or seek to reduce its risk of any suggestion that any decision made in respect of an employee, whether to dismiss them, disciplinary sanction, to put them on furlough, if there's a suggestion that that's been motivated in any way by someone raising concerns, whistleblowing concerns, having a whistleblowing policy in place helps throw water over them sort of accusations. If someone wants to raise formal concerns about health and safety, they can be reminded that there's a whistleblowing policy in place and it will be addressed as part of that whistleblowing policy. Again, there's nothing worse, and it will leave your clients and policy holders open to risk. If an individual raises that concern, it isn't directed anywhere in particular, and subsequently, that there is a detriment that the employee is put to. And lastly, it's easier said than done, I think, particularly at a time like this, to say to the client, well, this is the guidance from HMRC, this is what the legislation says. It can be a minefield. It's proved a bit of a minefield for us trying to get to grips, as I say, with the guidance and the updated sections of the guidance. And so at the earliest opportunity, clients, policy holders should be getting in touch with the insurance provider. There's, again, nothing worse than them getting in touch too late when we've already had a preliminary hearing and the company has potentially prejudiced its position, may prejudice its position in ACAS early conciliation, and that employee is then left with more grounds, or there's more suspicion on the employee's part, and as I say, someone without representation with the fire in their belly, they can see these claims through to the end without having any adverse costs awarded against them. What I'm looking to do, or try to do more so now, particularly because as a result of the COVID crisis, those claims that were listed in the tribunal were all taken out. They were all converted to telephone case management hearings, and they've been sort of kicked into next year. So claims that are now being issued, there's a bit of a backlog. Unless cases are listed for a day, which is which is rare. That would typically be where there's a dispute over pay. Hearings lasting 4 or 5 days, they're well into October, November next year. So in the meantime, what we're trying to do proactively is to apply for things such as judicial assessment, where the judge will set half a day aside by phone to let both parties know what the potential strengths and weaknesses are with the claim or the defence. And having, particularly with someone representing themselves, approaching the litigation in that way can sometimes result in a quicker resolution for the client, and they're not having to wait until the bitter end. Or judicial mediation. Again, that helps focus people's minds to the idea of reaching an agreement, because once directions are set, it can be the parties can become a bit blinkered, and they can just assume, well, we need to see this through to its fruition. So it increased the costs, and there's always that opportunity to head things off sooner. So those sorts of hearings, I think, are on the rise. Judicial assessment, judicial mediation. But as I say, employees who have issued claims where you think on the face of it there isn't that much merit to this, it's very difficult to stop those claims proceeding. Applications for strikeout, so that's to say to the judge, look, this claim is going to struggle, we want you to strike it out. Very unlikely where someone isn't represented. So it has been a tricky period for employers, and I think it's just emphasised the need where possible for them to have an insurance policy in place, and for them to consider at what point they're able to seek assistance. And I think that's all from me, Chris. Thank you.
Thank you very much, Adam, indeed. I appreciate that we've just run over the hour, and I truly apologise for that. But what a fantastic presentation that's been.
So thank you to you all for that. I mean, there's an incredible amount of insight there, and sector-specific expertise. And if you imagine trying to get all of those solicitors in one room would cost thousands and thousands of pounds for that sort of advice. Plus, you've got my day rate on top of that as well. So very, very insightful. So thank you very much, gentlemen. So we've got a few questions here that we'll field that have come in prior to the meeting. So first and foremost, that's a nice easy one for me. Can your policy be sold as a standalone, or is it available on scheme business only? The simple answer to that is that our commercial legal offerings, or standard offering, can be offered on a standalone basis, but our haulage business is on a scheme-only basis. Good news for you is that our scheme commitments are incredibly low. So if any of you are coming out of this thinking, well, actually, do you know what? I want to partner with Stephensons, I want to partner with ARAG, my contact details are on the end, and we'd be more than happy to have that conversation with you. Question 2, how should hauliers be responding to the increase in gig workers from a HR perspective? I will leave that one for you, Adam.
Thanks, Chris. I think a company finding itself in this position, particularly the likes of hauliers or construction companies, where individuals hold themselves out almost as contractors, you end up in a situation where, from the company's perspective, if there's a dispute over their employment status, you would want them as being recognised as self-employed, because the claims that are being brought generally will be, I'm owed holiday pay, I've worked here for the past 10 years, and I've accrued rights. And the company's position is, you're not employed by us, you're self-employed, you're a contractor. And a lot of the policies that I've assisted with, or generally speaking, would cover or wouldn't necessarily distinguish whether or not you're defending claims against a worker or an employee. Someone who's clearly self-employed, they struggle to even get the claim started at tribunal. But in order to reduce the risk, it's important to have in writing what the arrangement is with that particular individual. There is nothing worse than someone who has been turning up to the same location for 10 years, having given work from that place. It's more likely than not that they're going to be classed as at least a worker, if not an employee. Now, a worker attracts slightly different rights to an employee. Employees, bells and whistles, unfair dismissal. a worker, they're able to claim accrued holiday pay, entitlement to minimum wage, sick pay, etc. So in my experience, there isn't much of a difference in terms of who's going to be covered. We would defend it on the basis of, look, you're self-employed, the tribunal doesn't have jurisdiction to hear the claim.
Okay, thank you. Moving on, how many haulage companies are likely to be adversely impacted by the introduction of IR35 next year? Sean, do you want to have a...
Yeah, I wouldn't profess to be an expert in the IR35 rules. However, what I do know from my experience of dealing with clients in the sector is that a very large number of drivers work on the basis that they're self-employed, and despite that, a lot of them get all or the vast majority of their driving work from one supplier or one operator. And I think there's a hell of a lot, I don't know the exact numbers, I wouldn't be able to quantify it, but there's a lot of drivers that fall into that category, and I think it's fairly standard within the industry. And those are the people who are likely to be caught by IR35, and I guess the concern is that they don't necessarily all understand that. But it's that kind of arrangement that's likely to lead to drivers in particular being caught by IR35.
Mm-hmm. Thank you. And we've got is it fair to say that the position of hauliers who have contracts with the major online shopping providers are in the strongest position given the shift to people buying more online? If so, what challenges or problems could this potentially give rise to under the contract? For example, SLAs not being met by the haulier, or penalty charges, so on and so forth. It's a good question. I think from a legal perspective, I'm probably not advised to comment on that one, but of course we do have our partners there. One of the things that I would say is that obviously as part of our product, we can include cover there, as we've already outrightly put there, and as we've already discussed during the presentation, that potentially there are going to be more problems with people trying to get back to this new normal by taking on more than they can chew potentially. Would you have anything to add there, Sean?
Well, there's a bit of a food chain within the haulage sector as well in terms of quality of work, and there's people at the top of the food chain, and then there's operators towards the bottom of the food chain. So as this demand in certain parts of the sector increases, and with some operators perhaps being more desperate to please clients, please customers than others, or more desperate for work, I guess that one aspect to that is that there's a risk of some operators, again, prioritising economic interests over compliance, and possibly cutting corners and being more cavalier than they otherwise would have been to observing all the rules as far as driver's hours, maintenance of vehicles, etc. is concerned.
Great, thank you. Question 5, what is the view on the application of a COVID-19 exclusion on a haulier's public liability policy? So I can take that. Obviously, from our perspective, we don't do any public liability, so I think it's well worth at this stage speaking with the insurers who are looking for that. One of the great things from ARAG's perspective is that we don't have any pandemic exclusions, so we are truly looking to assist where we can, and granted obviously we won't cover anything under the public liability, but what we can do is give that advice and guidance from our expert solicitors who are on hand to answer any of those calls. With that in mind, actually, as part of COVID-19, our advice line has soared by over 50%. So we've been seeing lots and lots of people asking questions about their general insurance products because simply either they can't get through to the right people or they aren't covered. So it's really nice to have that reassurance that we do have experts on the end of the line who are able to assist there. But in terms of the application of COVID-19 exclusion, obviously it's quite a serious thing to have moving forward, and I would strongly suggest just checking with the insurers before in case of any issues there. Question 6, is there a view on those insurers who will remain silent with no specific exclusion, but no specific reference to this either? That's a really tough one. I think it's fair to say that, under any sort of ambiguity, that the insured would probably have the favour sort of lent towards them. From a position at ARAG, we try and be as clear and concise as humanly possible with what's covered and what's not. But I would dare say that if there are, if there is any ambiguity with your wordings that you've got with your insurers, just to highlight those before, just so that you're fully aware. But in the case of that getting contentious, again, I've got the legal team on the phone. I would say that more often than not that the insured would have that ruled in their favour. Would that be fair to say?
Yeah, I certainly if I was representing an insured where it wasn't specifically, the issue wasn't specifically excluded, acting in the best interests of that client, I will be arguing very strongly with the insurer that on that basis should be covered, because it's up to the insurer to make sure that policies are properly and clearly drafted, and if they're not, then as you've said, any ambiguity is generally found in favour of the policyholder.
Brilliant, thank you. Very quickly to wrap it up, I think it's incredibly clear now the exposures that are facing the haulage industry, and I think that's one thing that the clients are left exposed in a number of legal and contentious issues. I think, as we said at the beginning of the presentation, more focused than ever, perhaps now, is the need for that legal expenses policy to defend these clients, because without it, as we've seen, the awards of compensation can be vast. The threat of litigation is increased, perhaps more than it's ever been. So just ensuring that you've got a policy that actually talks the customer's language is incredibly important. As you can see from this wonderful presentation, we are very, very proud of our solicitor partners. It just goes to show, doesn't it, that the depth of knowledge that's at our fingertips in order to help our clients, and indeed we will continue to do so. And as I said, we are very, very proud of the partnership that we have. Outside of this, of course, all of our commercial policy holders have access to our 24/7 365 advice line. We do have some FAQs on our website. If you go onto our COVID-19 page at arag.co.uk, you can see all of the questions that have been asked there, not just from commercial, but of course from personal and landlords and tenants as well, if that's something that you specialise in as well. But I think adding this policy to your client's programme of insurances has to be on the radar, because of course with all of those kind of costs that were incurred there, somebody's going to have to foot that bill, but equally we want to make sure that, as we said at the beginning, our clients have access to justice exactly when they need it and at the right time and at the right level.
So thank you all for joining us today. I'm sure you'll agree that it's been an incredibly worthwhile discussion around the implications for the haulage sector. And we do hope to see you on our next of the Talk to the Expert series. So that's all from us for now. Enjoy the rest of your day, and hopefully we'll see you again soon.